Margaret Chen was cleaning out her mother's filing cabinet 3 weeks after the funeral when she found it. A letter, dated 4 months earlier, from the New Jersey Department of Human Services, Division of Medical Assistance and Health Services. The letter was addressed to her mother, Helen, who had passed away at age 81 after spending the last 18 months of her life in a nursing home receiving skilled care for advanced Alzheimer's. The letter said this: "This is to inform you that the state of New Jersey has placed a claim against your estate for recovery of Medicaid benefits paid on your behalf. The total claim amount as of this notice is $127,340. Upon your death, the state will seek recovery from your estate, including any real property, to satisfy this debt." Margaret read that letter 7 times before her hands stopped shaking. Her mother's house, the house Margaret grew up in, the house with her height marks on the kitchen door frame, the house her parents bought in 1987 for $140,000 that was now worth $430,000, was supposed to be hers. That's what her mother had said. That's what the will said. That's what Margaret had promised her own kids when they asked if Grandma's house would stay in the family. But the state of New Jersey had other plans. And here's the part that made Margaret physically sick. Her mother had no idea this was happening. By the time that letter arrived, Helen Chen's Alzheimer's was so advanced she couldn't recognize her own daughter, let alone understand legal correspondence from the state. Margaret called me 6 days later, and the first thing she said to me was this: "Karen, is it true that Medicaid can just take my mom's house? After everything she paid in taxes for 50 years? After everything we went through? Can they actually do that?" And I had to tell her the truth. Yes, in 49 states, Medicaid estate recovery is not only legal, it's federally mandated. I'm Karen, and this is Karen Retires. And if you or anyone you love has ever received long-term care paid for by Medicaid, or if you think you might need Medicaid in the future, what I'm about to show you could be the difference between your children inheriting your home and the state confiscating it to repay a debt you didn't even know you owed. Before we go any further, let me tell you who I am and why you should listen. My name is Karen. I'm a former estate planning paralegal turned retirement educator. I spent 14 years working inside law firms drafting trusts, probate petitions, and Medicaid applications for families who were desperately trying to protect what they'd spent a lifetime building. I am not an attorney. I am not a financial advisor. I am not giving you personal legal advice. What I am giving you is a roadmap, the same roadmap I wish someone had handed to Margaret Chen's mother 5 years before she needed a nursing home. This channel exists because I got tired of watching families get blindsided by laws that are written in plain English but hidden in bureaucratic fine print. If this is your first time here, subscribe right now. We don't do fluffy retirement listicles. We do surgical breakdowns of the legal and financial landmines that can wipe out decades of work in a single probate proceeding. And if you've been here before, hit that like button. I know that sounds like a vanity request, but here's the reality. YouTube's algorithm in 2026 actively deprioritizes financial content that doesn't get early engagement. Every like in the first hour tells the platform this video matters and pushes it to one more family who needs to see it before it's too late. Do it right now. I'll wait. Good. Now let's get into the law. Here's what most people don't understand about Medicaid. Medicaid is not Medicare. Medicare is the federal health insurance program for seniors 65 and older. You pay into it your whole working life through payroll taxes, and when you turn 65, you get benefits. Pretty straightforward. Medicaid is different. Medicaid is a joint federal-state program that provides health coverage to low-income individuals, including long-term care services like nursing home care for people who have spent down their assets and can no longer afford to pay out of pocket. And this is the part they don't put in the brochures. Medicaid is not a gift, it's a loan. Under federal law, specifically the Omnibus Budget Reconciliation Act of 1993, or OBRA 93, every state is required to attempt recovery of Medicaid benefits paid to individuals age 55 and older for nursing facility services, home and community-based services, and related hospital and prescription drug costs. Let me say that again. Required. This isn't optional. This isn't some rogue state policy. This is federal mandate. When you or your parent applies for Medicaid to cover long-term care, you're signing paperwork that includes a clause authorizing the state to pursue a state recovery after death. Most people never read it. Most people are so desperate to get mom into a safe facility that they'd sign anything. But that signature has consequences. The moment Medicaid starts paying for care, the state starts keeping a ledger. Every month of nursing home care, at an average cost of $8,000 to $12,000 per month, gets added to the balance. Every prescription, every therapy session, every medical transport. When the Medicaid recipient dies, the state files a claim against the estate, and the primary target is the home. Why? Because for most American families, the home is the only significant asset left by the time someone qualifies for Medicaid. Everything else, the savings, the retirement accounts, the car, has already been spent down to meet Medicaid's strict asset limits. The house is what's left, and the state knows it. Now here's where it gets complicated, and where most families make catastrophic mistakes. Not all Medicaid estate recovery works the same way. There are actually 3 different mechanisms the state can use, and which one applies to you depends on timing, state law, and whether certain people are living in the home. Let me break down all 3. This is the most common form of recovery, and it's what happened to Margaret Chen's family. When the Medicaid recipient dies, the state files a claim against the probate estate. If the home passes through a will or intestate succession, meaning no will, it's part of the probate estate, and the state gets in line with other creditors. Here's the order of priority in most states. Funeral expenses, estate administration costs federal taxes, Medicaid estate recovery claim, other creditors, beneficiaries. Notice where the beneficiaries are, dead last. If the estate doesn't have enough liquid assets to pay the Medicaid claim, the executor is often forced to sell the house to satisfy the debt. Margaret's mother owed $127,340. The house was worth $430,000. After funeral costs, probate fees, and the Medicaid claim, Margaret walked away with about $280,000 and lost the family home. Under the Tax Equity and Fiscal Responsibility Act of 1982, yes, this goes back to Reagan, states are permitted, not required, to place a lien on the home of a Medicaid recipient while they're still alive if they're permanently institutionalized and unlikely to return home. This is rarer, but it happens, and when it does, it's devastating. If your mom is in a nursing home and the state determines she's never coming home, they can file a lien on the property immediately. That lien sits there, quietly attached to the deed, waiting. You can't sell the house without paying off the lien. You can't refinance. You can't do anything until either the Medicaid recipient dies and the claim is settled, or the recipient returns home, which terminates the lien, or you pay off the Medicaid debt in full. Here's the one that terrifies estate planning attorneys. Some states have adopted what's called expanded estate recovery, which means they define estate more broadly than just probate assets. In these states, the definition of estate can include assets held in joint tenancy with right of survivorship, assets held in a living trust, assets transferred via payable on death or transfer on death designations, basically anything the deceased person had an ownership interest in at death. As of 2026, states with expanded estate recovery laws include California, most aggressive, Oregon, Washington, Iowa, North Dakota, and several others. In California, even if you put your house in a revocable living trust to avoid probate, the state can still go after it under the expanded estate recovery statute. Let me be very clear. This means that the traditional probate avoidance strategies do not protect you from Medicaid estate recovery in expanded recovery states. That's the trap. That's what catches families off guard. Pause the video for 10 seconds and do this. Go to the comments and tell me what state you live in. Just type the state name. That's it. Why? Because I'm building a state-by-state resource guide for this channel, and I want to know where you are so I can prioritize the most helpful content. Plus, it helps other viewers see who else is navigating this in their state. Do it right now. I'll see you down there. Now let's talk about the exceptions, the cases where Medicaid estate recovery does not happen, even if benefits were paid. Federal law requires states to waive estate recovery if any of the following people are living at the time of the Medicaid recipient's death. A surviving spouse. If the Medicaid recipient's husband or wife is still alive, no recovery. A child under age 21. If there's a minor child, no recovery. A blind or disabled child of any age. Even if the child is 50 years old, if they're blind or permanently disabled, no recovery. A sibling with equity interest. If the Medicaid recipient's brother or sister has been living in the home for at least 1 year before the recipient entered the nursing home and holds an equity interest in the property, no recovery. An adult child caregiver. If an adult child lived in the home for at least 2 years immediately before the parent entered the nursing home and provided care that delayed institutionalization, no recovery. These are federal protections. Every state must honor them. But here's what you need to know. The burden of proof is on the family. If you're the adult child caregiver, you need documentation. You need doctor's letters, care logs, proof of residence. The state will not just take your word for it. And if you're a sibling with equity interest, you need a deed showing your ownership stake before your sibling went into the nursing home. Some states are more aggressive than others. Texas has some of the weakest estate recovery enforcement. They're required by federal law to attempt recovery, but in practice, they often don't pursue claims under $10,000. California is the opposite. Aggressive expanded estate recovery, and they will pursue claims as small as $3,000. Florida has relatively strong homestead protections that can shield the home in some cases, but those protections don't apply if the home passes through probate without a protected heir. New York is middle of the road, but has a hardship waiver process. If estate recovery would create an undue hardship, meaning the heirs would lose their primary residence, the state may waive the claim. Most people have no idea their state even has a hardship waiver process, and by the time they find out, it's too late to apply. All right, enough with the doom. Let's talk about what you can actually do to protect the home. I'm going to give you 5 strategies. Not all of them will apply to your situation. Some of them require advanced planning. Some of them have trade-offs. But all of them are legal, and all of them work if executed correctly. This is the gold standard for Medicaid planning. An irrevocable trust removes the home from your ownership, which means it's not a countable asset for Medicaid eligibility purposes if the transfer happens more than 5 years before you apply for Medicaid. That 5-year window is called the Medicaid look-back period. If you transfer assets within 5 years of applying, Medicaid will penalize you by delaying your eligibility. But if you transfer the home into an irrevocable trust, when you're 65 and healthy and you don't need Medicaid until you're 73, the transfer is beyond the look-back period. The home is protected. The state cannot recover against it. Trade-off. You no longer own the home. You can typically still live in it, but you can't sell it, refinance it, or change the terms without the trustee's approval. If you have an adult child who has lived with you and provided care for at least 2 years, you can transfer the home to that child without triggering the look-back penalty. This is one of the few Medicaid transfer exceptions that allows you to protect the home, even if long-term care is imminent. Trade-off. You're giving the house to one child. If you have other children, this can create family conflict. And if that child gets divorced, sued, or dies, the home is at risk. A life estate deed allows you to transfer ownership of the home to your children, the remainder men, while retaining the right to live in the home for the rest of your life. You keep the life estate. They get the remainder interest. For Medicaid purposes, only the value of your life estate is counted as an asset, and that value decreases as you age. In many cases, it drops below Medicaid's asset threshold. Trade-off. The remainder interest is considered a gift subject to the 5-year look-back. And again, you're giving up control. If you're paying a family member to provide care, formalize it with a written caregiver agreement and pay them fair market value for the services. This converts your assets, cash, into income for the caregiver and care for you, which can help you spend down assets to qualify for Medicaid without triggering penalties. And if you use a promissory note to structure the payments, you're creating a legitimate debt that can reduce the estate recovery claim. Trade-off, this has to be done correctly, with legal documentation. Informal payments to family won't count. If estate recovery has already been initiated, you may be able to apply for a hardship waiver in states that offer one. You'll need to prove that recovery would cause undue hardship, typically meaning the heir would lose their primary residence or sole income-producing asset. Success rates vary, but it's worth trying if you have no other options. Do me a favor right now, save this video. Click the 3 dots, hit Save to Playlist, and bookmark this. Why? Because 6 months from now, when you're sitting in an elder law attorney's office, you're going to want to come back and review these 5 strategies before that meeting. Save it so you can find it when you need it. Let me show you what this looks like in real life. Family 1. The Johnsons, Ohio. David and Linda Johnson did no planning. When Linda needed nursing home care at age 79, they applied for Medicaid. Linda lived in the facility for 2.5 years before passing away. Medicaid paid $287,000 in benefits. David was still alive, so no estate recovery was initiated while he lived in the home. But when David died 3 years later, the state filed a claim against the estate for the full $287,000. The house was worth $310,000. After probate fees, estate administration, and the Medicaid claim, their 2 children received $9,000 total. They lost the family home. Family 2, the Ramirez family, Florida. Maria Ramirez worked with an elder law attorney in 2017 when she was 68 and healthy. She transferred her home into a Medicaid-compliant irrevocable trust. In 2023, at age 74, she needed nursing home care. Medicaid paid $214,000 in benefits over 22 months. When Maria passed away in 2025, the state filed an estate recovery claim, but the home was not part of her probate estate. It was owned by the trust. The state recovered nothing. Maria's 3 children inherited the home, sold it for $385,000, and split the proceeds. Same diagnosis, same need for care, same Medicaid benefits. Different outcome. $376,000. That's the cost of knowledge. Here's what you need to do this week, not next month. This week. Step 1. Find out if your state has expanded estate recovery laws. I'll link a state-by-state resource guide in the description. Step 2. If you or a parent are over 65 and own a home, schedule a consultation with a certified elder law attorney, not a general practitioner. Step 3. If a parent is already in a nursing home on Medicaid, request a total claim amount statement from your state Medicaid agency. You have a right to know what the state says is owed. Step 4. If you're an adult child who has been providing care, start documenting now. Doctor's notes, care logs, proof of residence. Build your case for the caregiver exception. Step 5. Share this video with one person, a sibling, a friend, a parent. One share could save a family from losing everything. I'm Karen, and this is Karen Retires. I'll see you in the next one.